Welcome to another episode in my series of videos analyzing Web3 game legal issues. In particular, this week's episode is going to take a look at Web3 game token security law analysis. I'm Thomas Plunkett. I'm a professor of blockchain technologies at Harrisburg University. Also an attorney, licensed with the Virginia State Bar and the U.S. Patent Bar. Everything in this video and my other videos is based on U.S. federal law, and I'm not really going beyond U.S. federal law dealing with states or other countries. I've got a lot of exposure to blockchain. I've won prizes in blockchain hackathons. I've formed Web3 gaming DAOs. I've been an expert witness in Web3 gaming litigation. And at Harrisburg, I teach classes on Ethereum, Bitcoin, and cryptocurrency regulation. I myself have taken a lot of different courses in dealing with blockchain and cryptocurrency and cryptography and other topics from Stanford University. I have a master's degree in blockchain and digital currency from the University of Nicosia in Cyprus. I've also got a master's degree in computer science from Virginia Tech. And I've got a Bachelor of Arts and a Juris Doctorate degree from George Mason University. And I'm a published author on blockchain topics. Just a disclaimer, this presentation is not legal advice. This presentation is just a general statement on concepts of law. Legal advice, requires specific facts for a specific client and is based on an attorney-client representation relationship between the client and the attorney. So let's take a look. There's actually a lot of different potential legal issues that might apply to Web3 games, whether we're talking about legal entity formation, intellectual property rights for artwork and brands, securities law issues for tokens is going to be the topic of this video, but there's also things like anti-money laundering regulations, consumer protection issues, data privacy issues, gambling laws could potentially apply to your Web3 game, all as well as standard business laws like contracts and grants and employees, and tax regulations. And now with artificial intelligence being so popular, there's some new legal issues around artificial intelligence generated content based on large language models. So a lot of different legal issues out there, and I will have separate videos on all these topics and more. But today's video is going to dive into the security law analysis for Web3 gaming tokens. So specifically, now securities law analysis is very complex. This is a dense area of the law, dating back to the Securities Act, was passed after the Great Depression, as it's been amended over the years and interpreted by case law. And so any analysis of this area is going to be pretty in-depth and depend on a lot of different factors. But some initial questions you might think about is the project giving tokens away? In that case, the token is probably minimal risk if you're just giving it away to someone. For example, Bitcoin gives tokens to anyone who operates their computer and participates in the Bitcoin protocol as a mining system. And if they win the block award mining race, they receive tokens. That's minimal risk from securities law. I haven't heard anyone really make a persuasive case as to why Bitcoin should be subject to securities regulation. Now, what about if you're selling tokens to users? Well, in this case, a lot depends. The risk is greater than the minimal risk of giving the tokens away. But really, to a certain extent, this is pretty low risk too. For an example, let's suppose you're selling collectible cat artwork on the internet that someone can receive a non-fungible token with. Classic example of that is CryptoKitties, which was the very first NFT project on Ethereum. But there have been many other collectible cat artwork NFTs out there. And I have yet to see anyone claim that collectible cat artwork NFTs are subject to securities regulation, at least claim in a serious manner. But what if you're selling tokens to investors? Then I think there's significant risk. If your project's trying to sell tokens to investors, there's a significant risk that securities laws are applicable to what you're doing. Some examples, include like selling fungible tokens to investors, as we saw in several famous cases, including the Ripple Labs case, Telegram, LBRY, Terraform Labs, and so on. So let's step away from, at a high level and let's dive a little deeper. Let's think about Monopoly for a moment. Monopoly is a classic game. Um, it's been around for almost 100 years. Um, I think everyone is familiar with Monopoly. If you're not familiar with it, the basic idea of this board game is that you'll move your character represented by an avatar, which in some cases might be a car or a thimble or a top hat or another avatar around the board. And you'll have money that you can use to buy properties. And if you land on own property, you can buy it. And if you land on own property, you have to pay rent. Um, and so really there's three things in the game. You've got the avatars that move around the board game. You've got the money you can use as your sort of liquid asset to purchase things, whether it's purchasing the property or paying rent to land in a property. And then you have the other assets representing the property. In the case of Monopoly, we've got land like Boardwalk and Park Place and other streets. We also have trains and the electric utility and the water utility and so forth as the other assets you can purchase. Um, and we see this model over and over in a lot of games that have come out over the last 100 years. To take a more recent game, there's World of Warcraft. Well, World of Warcraft is this fantasy RPG, kind of similar to Lord of the Rings, where you've got orcs and humans, good guys and bad guys. Although World of Warcraft kind of makes the orcs good guys too. But it's basically a fantasy combat game where you kill monsters and you receive treasure, and then you can spend that gold, that virtual gold, to go and buy other things or perform other activities using the money, and perhaps collect other assets like magic swords and so forth. Um, and so if we think about it, comparing it to this Monopoly game, World of Warcraft has a virtual currency called gold, which is kind of similar to the money in Monopoly, and it's got other assets like magic swords and magic armor and so forth, kind of similar to the other assets that Monopoly has, like the property of the streets and the railroads and so forth. And then in both cases, you have an avatar that moves around in the virtual world. In Monopoly, the avatar is moving around the board. In World of Warcraft, the avatar is moving around a virtual world with a little more flexibility than this board offers. And if we think about many, many other games, whether they're physical board games or computer games, we see sort of the same model of having some sort of currency to purchase things, and then having other assets in addition to the currency, and perhaps also having some sort of virtual world in which your avatar can move and perform activities. So thinking about gaming and now returning to our securities law analysis, let's think about, should securities laws apply to what's going on with the Monopoly game? And if so, how would they apply? So the Monopoly game is actually produced by Parker Brothers. So if Parker Brothers issued stocks or bonds, then it would make sense that the Security Exchange Commission regulations are relevant to the stocks and bonds that are issued by Parker Brothers, just like they're relevant to any stocks and bonds issued by any other company in the US. But if Parker Brothers is just selling a Monopoly board game to a customer, then the securities laws aren't relevant, with one exception. The exception is if a company is selling that product, whether it's Monopoly board games or any other product, to the investors as an investment, not as a product to be used, then perhaps since it's being sold as an investment, it should be regulated as an investment by the securities laws. And this exception, called an investment contract, is really meant to cover situations where a company wants to raise money from investors, but they don't want to pay the expenses for issuing stocks and bonds or complying with the relevant security law regulations, which can be quite expensive. If you want to do a small fundraise, perhaps the expense of doing that small fundraise might be more than the benefit of doing the small fundraise. So if the company tries to hide an investment transaction by calling it a product transaction, but it's fundamentally an equity investment transaction, then the courts might treat that transaction as an investment that can be regulated by the SEC. And this all goes back to a Supreme Court case that happened not too long after the Securities Act was passed, called SEC versus Howey Company. So in the SEC versus Howey case, the Supreme Court held that under the Securities Act, An investment contract is a contract, transaction, or scheme where a person invests their money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. And so, if all of those factors are present, then the transaction is treated as a investment contract that is regulatable by the SEC. And therefore, if you engage in that without following the various regulations the SEC has put forth, you're violating the securities laws and subject to penalties. And in analyzing whether a contract is an investment contract, form should be disregarded for the substance, and the emphasis should be on the economic reality, as well as on the totality of circumstances. So you have to look at all of the facts and ask yourself this question: is this fundamentally an investment transaction, or is this actually a product transaction, for example? So let's think about how these things have been applied. So there's been a number of enforcement actions by the SEC where they've attempted to apply investment contract analysis to transactions involving tokens. And there's also been several cases that have actually received a decision in the federal district courts. So there is presidential case law on tokens being sold in transactions that were analyzed as investment contracts. And here's 4 of the leading cases up here on this slide. In SEC versus Telegram, tokens were found to be, sold in an investment contract. In SEC versus the library, LBRY, again, the court found that sales of tokens were an investment contract. Now, in SEC versus Ripple Labs, the court found that sales of tokens directly to the investors were investment contracts, but when Ripple Labs sold tokens on exchanges, those sales were not investment contracts. And if you want to dive into the details as to why, I'd recommend watching my video that covers the SEC versus Ripple Labs case. And then finally, in the last case, SEC versus Terraform Labs, in Do Kwon, sales of tokens there were found to be investment contracts as well. So there's significant precedential case law focusing on when sales of tokens to investors might be an investment contract. So let's think about this again, going back to our monopoly example. What if Parker Brothers or another company was to create a Web3 version of Monopoly, or really any sort of Web3 game where you're going to have some sort of currency and you're going to have other assets, similar to the, Monopoly's equivalent, which was the money and the properties that they had. So the monopoly money, the currency, would be fungible tokens based on ERC-20 or another fungible token standard. Now, the monopoly deeds to Boardwalk, Park Place, and so on, and other assets that aren't currency would be probably represented by non-fungible tokens based on the ERC 721 standard and other similar NFT standards. So if the fungible tokens and NFTs are given to users, then there should be minimal risk from a security law perspective, similar to how Bitcoins won through a proof of work mining race are a minimal risk under the securities laws. If the fungible tokens and NFTs are sold to users, still the transaction should be low risk regarding securities laws, just like the sale of Monopoly board game or another product is normally low risk for security law analysis. However, if the fungible tokens or NFTs are being sold to investors, there may be significant risk with security law issues under the Howey investment contract test analysis and the 4 cases I mentioned on the previous slide, LBRY, Ripple Labs, and Terraform Labs, and Telegram. So thanks for watching this video. My next video is going to be diving into gambling laws as applied to Web3 games.